This is case number 23, CR 55, State of Ohio versus Dennis L. Sears. Are you Dennis L. Sears appearing there from the jail?
Yes.
All right. This hearing is being conducted by Zoom. Mr. Sears has indicated he's appearing from the jail. His attorney is William Armentrout, who is also present at the jail in the video room with him. Appearing on behalf of the state is Assistant Prosecutor King, and appearing on behalf of the Probation Department is Officer Drew Balser. This matter is being conducted by Zoom, and Mr. Armentrout, you and your client both in agreement with that?
We are, Your Honor.
You're all right with that, Mr. Sears?
Yes.
All right. All right. Defendant was placed on community control for assault on a police officer, or on an employee of a local correctional facility, a fifth-degree felony, on November 24th of 25. There was a notification filed by the Probation Department on June the 15th of this year, and it alleged the defendant had violated Rule 2, hadn't reported since February 11 of 26, and Rule 15, he had a balance of $393 and failed to make any payments, court costs, I should say. Rule 15 requires him to pay the court costs or make payment arrangements with the clerk to do so. The court notified Mr. Sears of this alleged violation and appointed Mr. Armentrout, set the matter for hearing today. Well, actually, we set it originally on the 25th, and then it had to be moved due to scheduling conflict. So, Mr. Armentrout, have you had the opportunity to review the allegations with your client?
I have, Your Honor. He's prepared to admit that he hasn't reported since February and hasn't paid off the court costs.
All right. Mr. Sears, you do have a right to have a hearing on this matter, which is what this is for today, in which the prosecutor's office would have to present testimony and evidence to prove that you have failed to comply. You have a right to have your attorney cross-examine those witnesses. You have a right to present testimony and evidence on your own behalf. You're not required to do so, but you are permitted to do so. Now, in the event that it is found that you have failed to comply with these conditions, the court can do one of three things. I can continue your community control under the same conditions previously ordered. I could continue with additional conditions that I think are appropriate. And the third, the most serious, is that I could terminate your community control and sentence you to prison, since this is an offense of violence, for a period of between 6 and 12 months and fine you $2,500. Now, do you understand the allegations against you?
Yes, absolutely.
All right.
Yes.
And you understand your rights to a hearing and what's required to be shown by the state?
Yes.
And has anyone promised you anything or threatened you in any way to make you make an admission to this alleged violation?
Did you hear that? You got to speak up. Oh, no.
Okay, thank you. Yeah, your microphone's further away since the monitor's up on the wall than mine is, so it's, sound doesn't carry as easily. All right. Then is it your decision to admit to the violations as alleged in the notification filed on June the 15th?
Yes.
All right. All right. Anything from the State Probation Department regarding disposition in this matter?
Yes, Your Honor. The State and the Probation Department would ask that the defendant be continued on community control in order to complete the STAR program. There is a bed available for him at STAR on July 8th. That's all. Thank you.
Mr. Armentrout?
No, I understand and appreciate that the state is recommending continuing him on community control. But I know that STAR does things other than just alcohol or drugs. I know they do behavior modification. He's actually on disability for ADHD and depression.
ADHD and migraines.
And some type of migraines, Your Honor. Apparently, he had a house where he was living originally that was foreclosed on. Said he was removed. Somebody bought it. The sheriff removed him. I don't know that he notified probation where he was living with his girlfriend. I've talked to him about that relationship. It sounds like it's not in his best interest, but he basically has no place to go unless one of his brothers would take him in. But with what he draws on disability and food stamps, he could probably find an apartment. I don't think that, and he knows the routine that he's supposed to report. He hasn't done it. He doesn't have a vehicle. I just, maybe some kind of a wake-up call. And I was curious. I didn't know that this was just put on probation in November of 25 because it's a 23 case. I thought he'd been on longer than that, but maybe not.
No, I think it took a while. He was in diversion
Okay.
originally,
Okay.
and then
All right.
terminated from diversion.
So I just, I'm not the expert on Star. I just don't know what Star can do for him. I can see him being just the way he is. He's more haphazard than anything. I mean, he knew he was supposed to report. Claims that he didn't have transportation there. The girlfriend wouldn't take him. So I would ask the court to keep him on probation. He's got about 2 weeks in now since he was arrested, so he had done some time. I would ask the court if it felt appropriate, maybe give him some more county time and continue him on probation.
Mr. Sears, anything you'd like to say?
Speak up so we can hear you.
I've been trying, Your Honor, and I really want to get this over and done with, wrapped up, and I would make it to probation. I would happily go to probation each and every time and pass your tests and all this. If I could just, I just now got my money back started and everything, and I would happily pay the fines and fees off as soon as I can get out of here to do so. Other than that, the only thing I have is my girlfriend, in which I'd be living with her and her parents. And she just got a vehicle too, and she's been doing the Spark thing, and she would be able to give me a ride back and forth to probation at this point. I would happily continue the probation and complete it if you would let me do so. Thank you.
All right. Well, Mr. Sears, this is an offense of violence, and so probably, unquestionably, more often than not, people that get convicted of this type of offense go to prison. You were given a huge break by the state by being offered the opportunity to get into a diversion program, and if you completed it, avoid a felony conviction. You didn't do very well on that, and then I put you on community control in November, and then by February you weren't reporting. Now, understand you're claiming that you're dependent upon others, but you got 2 feet, you can walk. There's also a thing such as a phone, and almost everybody in the world has a cell phone now. And if you don't, people that do. You could have called. You didn't do any of that. Quite frankly, I'm surprised the state's recommending that you go to the STAR program because I don't think there's much chance of you being successful on continuing probation just by what you told me. You don't have a clue about the fact that you're responsible for your actions. You are responsible for making sure you comply, not your girlfriend or anybody else. It's on you. Now, as far as your issues, it said here in the PSI that you hadn't used alcohol since 2004, and you had a medical marijuana card at one point. But let's see, I'm looking here to see where it was. It says you do have ADHD. And you've been referred for that, following a domestic violence incident with your girlfriend at that time. I don't know if you're compliant with your treatment on that or not. But here's the deal. my thinking when I looked at this file yesterday is that you were going to get a prison sentence. They're offering you the STAR program. STAR program is a program that will provide both mental health as well as programming on trying to make people that have been doing criminal acts and non-compliant understand their behavior and allow them to change it. If I give you that opportunity, you have to successfully complete that. And if you don't, even if you get 90% of the way through, if you don't, then you're going to go to prison. And so I guess my question to you is, you said you want to get this behind you. You just want to do your time now, go to prison, get it over with, or you want to go to STAR and see if you can change with the understanding that if you don't comply, the next time you come back here, you'll go to prison. So I guess that's the two choices. I'm going to ask you what you want to do. Because if you don't want to go to STAR, if you don't want to be successful in that, and you're not going to try, then we're just postponing the inevitable.
You hear that, Judge?
I did not.
You need to speak up. He's electing STAR.
I'll go to STAR.
All right. Mr. King, I neglected to ask if you had notified the victim of the time, place, and purpose of this hearing.
He has opted out of notification, Your Honor.
Okay. All right. Thank you. All right. All right, then, Mr. Sears, I'm going to continue you on community control with additional conditions. One, that you successfully complete STAR program and any recommended aftercare. And one of the things they can do, if you are successful with that, when you get to the point where you're ready to complete, they can plan for transitioning you somewhere else. And if there's an indication of treatment needed, that may end up being into a transitional housing or something under some supervision, but not a lockdown facility. But you're going to be required to successfully complete the STAR program and recommended aftercare. And again, I emphasize the word is complete, successfully complete, not get to half of it or 3/4 of it or 10% of it. If you get to 99%, you get kicked out. That's a violation. It's got to be completed. You'll remain in jail till the bed's available. And that looks like that is, well, I thought we had that. What day is, oh, wait a minute, here it is. No, it's not that. Okay. What day is the STAR bed available, Mr. Bolswick?
July 8th.
July 8th, all right. So, till you go to STAR. And that STAR bed is July 8th. You're required to pay the additional cost. And I'm not going to extend it because the time that you absconded, from the time we issued that warrant for you, that doesn't count. And so it looks like, actually that was only in June. So, but it was about 4 months you absconded, so you're still going to have, and your time isn't going to count while you're in jail, or in the STAR program. So the time is told while you're in STAR. Well, no, it's not. I'll leave it. I'll just leave it that way. When you come out of STAR, you should have 2 years. That should give you enough time if you're serious about changing. If what you told me was, the truth and not a bunch of crap, and I'll give you an honest opinion. If you wanted me to place a bet, I'd say it's crap, but I don't mind if you prove me wrong. Hope you do. But it's going to be on you and nobody else. It's time for you to understand that you're responsible for your actions, not your girlfriend, not her family, not somebody else. It's on you. And in the future, if you don't have transportation, then, you can start walking. I've had people walk from Greenfield to court because I told them, telling me you don't have a ride is not an excuse. Because I tell people if you don't have a ride, I can get you one by putting you in the jail, and then they can make sure that you get to court. But that's not what was going on. You were on probation, so it's on you and no one else. So quit making excuses, start making changes. Anything else from the council?
No, Your Honor.
All right.
I want to talk to, are you still there, Judge?
Yes.
I want to talk to you about another matter while not
Okay.
involving Mr. Sears, if I can step out there.
All right, that's fine. Is this the same address, or are we going to go to a different notice for the sentencing? Okay. Case number 26 CR 49, State of Ohio versus James Franklin Gregg. You're James Franklin Gregg, appearing there from the jail.
Yes, sir.
All right. Mr. Gregg is appearing by Zoom with his attorney, Catherine Hapner, and Assistant Prosecutor King's in the courtroom on other cases, so he is present representing the state. The defendant is charged with 3 counts of rape. We had a discussion the last pretrial, and Ms. Hapner had indicated that she was going to file a motion to continue, and so the matter was set today for the status, and I believe I did receive that. And Mr. King is the alleged victim or representative of where the time, place, and purpose of this hearing?
Yes, Your Honor, and I advise everyone to monitor on YouTube.
Okay, all right. Are they on there now, or do you know?
They probably are because they probably weren't going to log in until 9:30.
All right. Well, we have a victim representative who wants to observe, so let me pause this, and we'll go ahead and check and have your office check and see if they can get in touch with them so they can log on now to Zoom or to YouTube, and so they're aware, because it was set at 9:30. So, all right. So we'll be back with you here in just a few minutes. I'll put you. All right. I'll mute you guys there. All right. All right, case number 26, CR 39, State of Ohio versus Terry Ray Harlow. Present on behalf of the state is Assistant Prosecuting Attorney Adam King. Present on behalf of the defendant is Attorney Danielle Witt. And are you Terry Ray Harlow?
Yes.
All right. Mr. Harlow has entered a plea of guilty to trafficking in drugs, a fifth degree felony. The matter was referred for a pre-sentence report, which I have received and reviewed. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
The state would just ask that the court follow the joint recommendation and place the defendant on community control and also order restitution to the task force. That would be in the amount of $30, Your Honor. That's all they need.
Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation. It's my understanding that he has been compliant with both probation and his intensive outpatient treatment at the Recovery Council, I believe.
Yeah.
So we just ask the court to follow that recommendation.
All right, Mr. Harlow, anything that you would like to say?
I have no excuse for it, and I'm just trying to count the legal where it is. Just move forward.
Okay, you can be seated. Well, Mr. Harlow, I was a little surprised to see you back here, as you had done, very well in drug court, graduated. But it's just another example of the disease and the fact that the monkey's never off your back. And you have to always be vigilant and work real hard at staying focused. And, it looks to me like you sold a small amount, and, basically because you were using again. And, that's regrettable. But the state's agreement, I agree with the state's assessment that this should be community control because I think you can stay clean. And so I'm going to follow the recommendation as the order of the court. Should be sentenced to a term of 3 years of community control under the supervision of the probation department. Be required to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed. Be truthful in all statements you make in the probation department. Keep them informed of your residence, place, employment at all times. May not change either without prior permission, and may not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate at any of those facilities, or attempt to without written permission in advance. You're not permitted under federal or state law to have any firearm, ammunition, dangerous ordnance, and to do so would be a felony under both federal and state law for which you could be prosecuted. It's also a condition you not have any of those or any other types of weapons while on community control in this case. You're not permitted to purchase, possess, use, or have in your control a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to those. Normally, you have any instrument, device, or thing that may be used to administer drugs. You prepare them to be administered unless you have a legal prescription, both for the substance as well as the device. You must provide copies of any legal prescriptions to your probation officer within 24 hours of receipt. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverages, nor may you be present in places where they're sold or being consumed, even if it's otherwise lawful. You shall not associate with any co-defendant or any other person who has a criminal record, a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless approved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation in the common law marriage type relationship with another without written permission. You must report any conviction, arrest, citation, or the charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees, costs, or restitution will be reviewed. If you are referred by the probation department for an evaluation or assessment for any type of treatment, therapy, counseling, training, or other programming, you're to submit to that. There's a recommendation for programming you're to enroll in and successfully complete that. You'll be required to successfully complete the SUD, substance use disorder, this abbreviated SUD in your entry, treatment at TRC, Recovery Council, and recommended aftercare. Now, by being placed on community control, Mr. Harlow, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, or used by you, or any of the property places under your control where you're found at any time, any officer of the probation department. There'll be no fine assessed in this case. You're ordered to pay restitution in the amount of $30 Hiding County Task Force payable through the Victim Restitution Escrow Account and pay any service fee charged for that. You're also ordered to pay the court cost, and if you don't make payment arrangements and comply with that, it's a violation of your conditions, but it's also would subject you to having the clerk collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have, referring it to collections, which would require then you pay an additional 30% for the cost of collection. And if that doesn't pay it, then the court could permit you to do community service in this county. You'd be given credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that you are alleged to have failed to comply with these conditions by probation, they will file a written notification of the court. There will be a hearing at which you'll be entitled to have an attorney. The outcome of that hearing is that you have failed to comply. And at that time, the court can revoke your community control and sentence you to a prison term between 6 to 12 months and fine you $2,500. If you're convicted of another felony and sentenced to a term of incarceration for that offense, that could order be served consecutively to the sentence in this case. If that occurs upon completion of that prison term, it is optional under the law that Adult Parole Authority could put you under post-release control supervision for a period of up to 2 years on a term set by the court. And if during that time they found that you had failed to comply, they could return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. But if you're convicted of a new felony and receive a prison term, then in addition, whatever sentence the judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further, counsel?
Was restitution addressed, Your Honor?
Yes.
I'm sorry, that's it. Yeah.
All right, then this completes your case, and then Mr. Harlow, you're no longer under pretrial supervision. See Officer Benson on the way out to make your appointment for your transition over to supervision. All right, thank you. All right, we're back on record. State versus James Gregg, 26 CR 49. And Mr. Gregg and his attorney are appearing from the jail by Zoom, and Mr. King, as on behalf of the state, is in the courtroom. And Mr. King, my understanding is the alleged victim or representative is now monitoring the hearing on YouTube.
That's correct, Your Honor.
All right. All right, so this is before the court on a motion to continue. We discussed at the last pretrial that since there wasn't anything in writing, we needed to have a hearing on that with the alleged victim or representative present or available to be notified to have the opportunity to be present. We scheduled this hearing today. All right, Ms. Hapner.
Thank you, Your Honor. I did file a motion to continue last week. As we discussed at the last pretrial, these are serious charges that carry a penalty of up to life in prison. And while I've been discussing the case with my client, there are still issues and things we need to further discuss. And I think it's scheduled for trial next week, and that simply isn't time enough for us to get in here. I've discussed with my client, and he also wishes to have a continuance.
Is that correct, Mr. Gregg, that you're willing to waive your speedy trial time under the law in order to extend this matter for a limited period of time to give you and your attorney more time to prepare?
Yes, sir.
All right. All right, Mr. King.
The state has no objection to the continuance, Your Honor. I understand it's certainly a reasonable request given the serious nature of this case. We did consult with the victim's rep, and they were opposed to a continuance. But again, the state understands the reason for the request in this case, Your Honor.
And the trial is currently set for the 6th, I believe, right?
The 9th, I believe.
Or the 9th? Okay. Yeah, 9th and 10th. All right. Well, I understand the alleged victim or representative alleged victim's reluctance to have the matter continued. But one of the things that in this situation was that the defendant was not indicted until May the 5th. And he had been charged, I believe, and bound over. Looks like he was charged on April the 16th. And so under the speedy trial law, which allows 90 days for a trial when somebody's being held in jail, the court set the matter just slightly over 2 months, which is a relatively short time. And while alleged victims feel that, I understand the feeling they want to get the matter decided quickly. Quite honestly, in this court, we've tried cases and big cases to dispose of probably, if not the fastest in Ohio, and certainly in the top 5. Having a rape case set within 65 days of arraignment is unheard of in most jurisdictions. Again, I set the trial date with the full understanding that, in my mind, that any responsible attorney would probably need more time to prepare, given what's at stake here for the defendant, but also it's better to have more time for that for the state as well, and not to mention the fact that if court forced this matter to trial, denied the continuance, if there is a conviction, it would undoubtedly be one of the primary errors assigned on appeal of denying the continuance to allow more time for an effective defense. And so rather than take that risk, which is also not in the best interest of the alleged victim in my mind, I'm going to grant the motion. So we will continue this case. Let's see what our next available criminal date is. How many days to try this? We have it set for 2. Is that
That would be plenty,
sufficient?
Your
You
Honor.
agree with that, Ms. Hapner, 2 days would be sufficient?
Yes.
All right. I'm looking at August the 17th. I just buzzed Miss Ware to see if what's going on with that. We have a couple of cases. Is that available for you guys?
Not Your Honor. That's my regular day in Fayette
Okay.
County.
All right, doesn't matter then. All right. How about August the 20th? Break my heart to change my dentist appointment.
I just changed it.
August the 20th and 21st? Oh, wait a minute. I've got a court trial set on the 21st. What about the following Monday?
I'm
The 21st?
I'm actually scheduled to be out the 22nd to the 29th.
Okay.
Oh, yeah, I've got her down. She's out.
Oh, yeah, I see that.
I think I gave those dates to Mrs. Wood.
Actually, how about August the 3rd? I have a civil trial set, but they're all settled.
That's my regular day in Fayette County. The 3rd, the 17th, and the 31st are my days in Fayette in August.
Let's see, the 10th is out because we have craft set for that date.
That's scheduled for a plea tomorrow, Your Honor.
Oh, it is? All right. And then we have, well, how about the 10th?
Yeah, I'm available the 10th and 11th.
The other cases are all more recent, so. Let's see, Montgomery, Tedford, Neal, none of them are in jail, are they?
Tedford is, but in a different, he's being held, I think, in a different county.
He's pleading, you say?
No, I think he's being held for a different county.
Oh, okay, Tedford,
Neil's in jail also.
and he is. What are they charged with? You remember off the top of your
Neil
head?
is rape.
What's that?
Neil is rape.
Oh, Neal is a rape case?
He's doing a stipulated polygraph, though, that should take care of that case one way or the other.
We haven't continued that one, have we?
Yes.
We did? How about the 13th?
Yeah, I could do that. I'm scheduled for municipal court, but I think I can move that day. Move that court.
All right. Well, I have drug court on the 14th, but it's the small one. So what I'd probably do is move that to the afternoon. Because a day and a half is probably enough to get the evidence in it.
I think a day is probably enough. We should definitely be done in a day and a half.
Okay. All right. Well, let's go ahead and set for the 13th of August then. At 8 a.m. And we'll set a final pretrial.
Just gonna play
Yeah.
one.
All right. July the 22nd, you're scheduled here, Ms. Hapner. So on another case, Lily for ILC plea. So we'll set the final pretrial at 1 o'clock on the 22nd of July.
That's good.
All right. Now, are there any other matters we need to discuss at this point? Have you filed your compliance with discovery yet?
I have not. There's a few things that I need to get from Mr. Bragg that are on his iPad here at the jail that he's got to figure out a way to get those downloaded to me.
All right, I'm going to order your compliance with discovery be filed by today is the 1st, July the 8th. And also any pretrial motions. All right. State have anything else?
No, Your Honor.
All right. So the court then grants motion for continuance. It's ordered the trial be set on August the 13th at 8 a.m. Final pretrial on July 22 at 1 p.m. And as the time is being charged on the speedy trial to the defendant pursuant to revised code 2945.72H, motion on behalf of the defendant as well as the defendant's time waiver. All right. Thank you.
Thank you.
Your Honor. Should I log off to the jail or expect?
Yes, please. We're going to do another hearing now. Thank you. This is Rachel Nicole, State of Ohio versus Rachel Nicole Baker, 26 CR 027. Are you Rachel Nicole Baker appearing there on the screen marked Jeff Horton?
Yes, sir.
All right, this is a sentencing hearing. Defendants appearing by Zoom from the treatment facility. Her attorney is Danielle Witt, who is present in the courtroom, and representing the state is Assistant Prosecuting Attorney King, also present in the courtroom. Ms. Baker, are you okay with having this matter conducted by Zoom rather than being up here in court with your attorney?
Yes, Your Honor.
All right. And have you had an opportunity to consult with her? Do you need to talk with her about anything before we go further?
I am fine proceeding further, yes.
Okay. All right. So the defendant entered a plea of guilty to aggravated possession of methamphetamine, a 5th-degree felony. And as I indicated, the matter was referred for a pre-sentence report, which I have received, and have each of the attorneys had an opportunity to review a summary.
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
It only was contained in the plea agreement, Your Honor.
Ms. Witt?
Yes, Your Honor. We also asked the court to follow the joint recommendation. It's my understanding that Rachel has been doing very well in treatment. She's been at the counseling center for almost 4 months now, an inpatient, and has been compliant as far as my knowledge goes.
All right. Ms. Baker, anything that you would like to say regarding the sentencing?
I would like to just give a quick update. I have been moved to transitional living as of Monday this week. So I am in a different housing now with the counseling center. So I did just want to update you guys on that. But it is still with the counseling center. So.
All right. Well, it is the order of the court then that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department. Must keep them informed of your residence and place of employment at all times. May not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. If you do, you have to have that pass on your person when you are traveling. You may not enter upon the grounds of any correctional facility or attempt to enter upon the grounds of any correctional facility or communicate or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Now, because of your conviction, you're not permitted under either state or federal law to have under your control or to purchase, possess, use, or own any firearm, ammunition, or dangerous ordinance. To do so would be a felony offense under both federal and state law for which you can be prosecuted. It's also a condition you not have any of those or any other weapons of any type while you're on community control in this case. You're not permitted to purchase, possess, use, have under your control any controlled substance, drug abuse, or any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription both for the substance as well as this prescription. You may not, also are not permitted to have CBD oil, kratom, or any variant or analog of any controlled substance or drug of abuse that has effects similar to those without written permission. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under control any alcoholic beverage or be present in any places where they're sold or being consumed, even if that is otherwise lawful. Not to associate with anyone who has a criminal, any co-defendant in this case, I don't think there are any, or any other person who has a criminal record, member of a gang, or any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violates these conditions unless that's approved in writing by your supervising officer. That includes any family members that were may fall within that definition unless you were living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any restitution fees or costs can be reviewed. If you're referred by the probation department for any evaluation or assessment for any further treatment, therapy, counseling, training, or educational programming, then you are to submit to that, and if there's a recommendation for programming, you're required to enroll in it and successfully complete that. You pay the court costs of this action and make payment arrangements to do that. You're required to successfully complete your substance use disorder treatment, which is abbreviated SUD, in your entry at the counseling center, which is abbreviated TCC, and you're still in that treatment, and that includes transitional treatment housing, and any recommended aftercare that they may suggest. Now, by being placed on community control rather than being sentenced to prison, you're deemed and consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed that's under your control where you're found anytime any officer of the probation department. There'll be no fine imposed in this case. You're also ordered to pay the court costs as a substantive order. It'll be a violation if you don't make those payments on those of your community control conditions, but it's also then, if you fail to do that, would allow the clerk under the law to take steps to collect that by levying on bank accounts, wages, earnings, or other assets you may have, or refer it to collections for them to collect it, and then the collection agent would be entitled to charge you an additional 30% above what you have to pay in the court cost. If none of those options get the cost paid, then the court could permit you to request to do community service in this county, and you would then be given credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
No, Your Honor.
All right, that completes your case then, Ms. Baker. The pretrial supervision requirements are now lifted. You're under these conditions. You'll need to reach out to probation departments, set up an appointment, probably by phone or Zoom, to discuss your new conditions and reporting requirements. All right, do you have any questions?
Yes. No, that is everything. Thank you.
Thank you.
How you doing, Judge?
On record.
All right, good morning. Now, this is case number 25 CR 141, I'm sorry. State of Ohio versus Cornelius Crosby. And you're Cornelius Crosby appearing there from Madison Correctional?
Yes, sir.
All right, this is a hearing on Mr. Crosby's motion for judicial release was filed pro se. He is appearing by video from the Madison Correctional, obviously. The state is represented by Assistant Prosecuting Attorney King, appearing from prosecutor's office. The defendant was convicted of failure to comply, a third-degree felony, on October 30th, 2025, and was sentenced to a term of 30 months. He filed his motion for judicial release, and the court did order a report, which I've received from the probation department. All right, Mr. Crosby, I have read your motion and the report. Is there anything that you would like to say regarding your request?
I would say thank you. Thank you for giving me another chance, and I don't learn my lesson. And my kids really need me, so I've been going to school, so I might do that when I get out too. Trying to get my GED.
All right. Mr. King, anything from the state?
The state has no objection to the motion, Your Honor.
All right. All right, well, Mr. Crosby, the court has reviewed the file, and it is the order of the court that your motion be granted, and that you'll be released on July the 7th to the custody of the Sheriff's Department and brought back to Hyden County Jail, and you'll be placed under community control for a period of 3 years. Now, the conditions of that will be as follows. The primary condition, the first condition is you're going to go to the STAR program, and that is a program that's operated down in Franklin Furnace, and there's a bed available for you on July the 8th. And that'll be it's called community-based correctional facility, and they offer programming that the court has found to be helpful in many situations if a person's willing to utilize that program. And so it'll be required that you successfully complete that program and any recommended aftercare once you have completed the program, which usually lasts between 90 and 180 days. Now, it means that you must be successful. It's not that you participate and get halfway through or 3/4 of the way through or even 99%. It's going to have to be 100% success. Now, you'll be under supervision of the probation department under the additional conditions that, first of all, it'll be for 3 years, and that you'll be required to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, be truthful in all statements you make to the probation department. You must report to your supervising officer when and as directed. Shall keep them informed of your residence and place of employment at all times. You're not to change either of those without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission, and you must have that pass with you when you're traveling. You may not enter upon the grounds of any correctional facility or communicate or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. And that means once you're released from STAR, because STAR are other people that do have records. You're not permitted under the law to purchase, possess, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapon of any other type. And if you do possess, purchase, or own or use a firearm, ammunition, or dangerous ordnance, you'll be prosecuted. In addition to being in violation of these conditions, you can also be prosecuted for an additional felony under either federal or state law or both. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage or any controlled substance, drug abuse, or any instrument, device, or thing that may be used to administer them, prepare them for administration, unless you have a lawful prescription for both any substance as well as any device. You must provide a copy of that within 24 hours to your supervising officer. You're not to be present in places where alcohol is being sold or consumed, even if it's otherwise lawful, and you're to submit to drug testing when and as directed. You're not permitted to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. And that includes any family members, unless you were living with them immediately before the commission of this offense. You're not permitted to marry or establish a new cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement, an arrest, citation, a conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any further treatment, therapy, counseling, training, or programming beyond that ordered by the court, you're to submit to that. If there's any recommendation for programming from that evaluation or assessment, then you're to enroll in and successfully complete that. You're to pay the court costs of this action, make payment arrangements to do that. Now, by being placed on community control and being released from prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control, or where you're found at any time by any officer of the probation department. Now, if it's alleged that you have violated any of these conditions, the probation department will file a written notice that with the court and give you a copy. There will be a hearing in which you'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and return you to prison to serve the balance of your sentence. You should be convicted of another felony offense while on post-release control supervision. Under judicial release, community control supervision, and receive a prison term for that. Any prison term you receive in that new case could be ordered to be served consecutively to the sentence in this case. All right, now we'll file this entry today along with the STAR entry, send it to the sheriff, and send a copy of the institution, and the sheriff will be there to pick you up on July the 7th. You have any questions, Mr. Crosby?
No, sir. And I said thank you for giving me another chance.
All right, well, good luck. Thank you.
Same to you. You too, sir.
All right. We have two cases involving the same parties before the court. Case number 21 CV 172 and 25 CV 296, both styled Highland County General Health District versus Connie Henderson. Appearing on behalf of the plaintiff, Prosecuting Attorney Collins, Assistant Prosecutor King, and Philip Webb as representative of the plaintiff. And you are Connie Henderson?
Yes.
All right. The matter before the court in each case is a motion for a finding of contempt. In case number 21 CV 172, the court issued an order, I believe back in 2022, February 28 of 22, and joining the defendant from allowing accumulation of solid waste and trash on the premises, and enjoining that future. The plaintiff has filed a motion on May 20th that alleges that the defendant has continued to accumulate solid waste on the premises in violation of that entry. In case number 25 CV 296, in that case, that was an action that the court granted an injunction because the defendant did not have a properly operating sewage treatment system and was allowing, there was ponding of liquid and bleeding of sewage water, gray water onto the surface. And that was issued on December the 2nd of 2025. And she was ordered to install a proper sewage system and remove all solid waste within 30 days. And the plaintiff filed a contempt motion on May the 28th, alleging that she had failed to do that based on an affidavit signed by Mr. Webb, indicating he inspected the premises on May 13, and that she had not removed all solid waste and or installed an approved and operating system. The court issued the order for the defendant to appear on a show cause hearing for contempt in each case for today. All right, Ms. Henderson, you're not represented, is that correct?
No, but Your Honor, I would like to get a lawyer.
Pardon me?
I would like to have a lawyer, please.
Well, you are entitled to hire an attorney, and if you are going to hire an attorney, I mean, you had, over a month to do that. Are you planning on hiring an attorney?
Yes, sir.
Okay. Have you talked to any attorneys?
I've talked to 2 of them.
All right. So have you made any arrangements yet for that?
Probably when I get home, I will.
I'm sorry?
When I get home, I will.
Okay. And how soon will you be able to do that?
That depends on the lawyer.
Well, I'm asking you how soon you can do it. That's what I'm asking, because I'm not going to continue this indefinitely. I can give you a short period of time. I'm asking you how reasonable is it that you're going to hire an attorney?
Within the next week.
Within the next week, all right. Before we go into that, I received this from my assistant that indicates it looks like you provided something about a utility statement here.
I paid on my
paid
sewage.
On July the 1st. You paid $50 on the $1,896. Okay, so this is a situation where she was disconnected for non-payment.
Correct, Your Honor.
All right. Has it been turned back on?
She's going to talk to him and see if it can get turned on.
Okay.
She has to pay the balance to get it turned on, is my understanding, I believe, Your Honor.
That's what I thought.
Paid $50, she's not.
Just payment. All right. Okay. Well, because I was just wondering about that. All right. So that's not going to affect the matter at this point. All right. I'll grant you a continuance for the purpose of employing an attorney. You need to be talking to somebody right away, and I'm not going to, wait until the day before, the day of, and have an attorney file a motion and say, hey, I just got hired, I can't be there tomorrow or today. If that's the situation, save your money. All right, we'll continue this until July the 30th at 9 a.m. So that gives you 4 weeks. And you've had already over a month. So, like I said, if you're going to hire somebody, make sure they don't know that that's the hearing date. And it's not a real complicated matter. Quite honestly, it's just, have you complied or not? And you need to make sure that they understand that.
Okay.
All right. Anything further from council?
No, Your Honor.
All right.
Thank you.
26, State of Ohio versus Pharaoh E. Keltz. This is a pretrial being conducted by Zoom. Mr. Keltz is represented by Jacob Wagner, appearing from his office. Appearing on behalf of the state is prosecuting attorney Collins from her office. The defendant is charged with one count of attempted murder. Ms. Collins has the alleged victim of the charge been notified of the time, place, and purpose of this hearing.
Your Honor, there is no victim's rep to notify.
All right. Is he still in a facility?
He is in a facility, but doesn't understand if we were to tell him.
Okay. All right. So this is set for the final pretrial. We have a trial date set on the 20th of July, although I do believe that there's been an evaluation, and so I guess actually we're actually still on for that day. Where do we stand on that report, Mr. Wagner or Ms. Collins?
Your Honor, I guess I can say Ms. Collins and I have in concert been trying to get I'm not saying trying to get a hold, that sounds incorrect, because we've not got an update on the report from Dr. Fabian at this time. I was with Collins' office today going over cases. There was an email sent from her office requesting an update. Annika may be able to speak more to that, sir.
Ms. Collins?
Your Honor, on June the 10th, when we sent everything to him that he had been appointed and everything, his assistant, the executive assistant to Dr. Fabian, said that it takes approximately 45 to 60 days for the completion of the report.
Okay.
So it hasn't even been 30 yet.
Let's see. I'm looking at the date I signed that order. Looks like around filed on May the 28th. And the order was signed on June the 8th. Okay. So at this point then, our trial date doesn't look too good. So I guess we need to talk about that. Then also, before we get to that, are you anticipating any other types of motions, Mr. Wagner?
No, this would be the extent, sir.
Ms. Collins, anything else that you can think of?
I agree with Mr. Wagner. I can't think of anything else. I'm wondering if this can be looked at the same as a competency evaluation, that it can be placed on the inactive docket?
No, I don't believe so, because it's a request for it is evaluation, so to speak, but it's really not a competency, or because he's not asked to rule on that, to opine on that. He was asked to opine on the battered child syndrome.
I was just trying to think of a way to.
Obviously, Mr. Wagner, I assume you don't want to go to trial without this report.
No, we will waive time. I think we already have. If not, we will execute a time waiver.
Well, let's do another motion and execute a new time waiver. And I'll put this trial back. Let's see. If we're going to allow 60 days, and I sent it to him and it was signed on June the 8th, we're talking August the 8th. And so,
excuse me,
I would think we would be looking at probably a late August then. How many days do you anticipate this taking to try, Ms. Collins?
2.
All right.
It's not a complicated case,
Right.
other than
Right.
the issue that we're having evaluated.
Sure. You agree with that, Mr. Wagner?
I would, Your Honor. And not that my opinion or preference matters. I'd prefer just try it late August, do it before the fair break. Just let's get it.
Right.
I know it's busy for Ms.
August,
Collins, though.
Let me better get the calendar here. I know there was one date I had a free when we talked about this morning, but I can't remember what date it was. Let's see, August. Huh? Okay. And Let's see. August 31. What do we got that day? Civil.
I don't know anything about this. Atlas and Greenfield.
Yeah. I think it's got a summary judgment pending.
I think so. The other one.
Yeah, the first is a grand jury. So,
That's that Greenlee case with that garbage representative.
oh yeah.
So,
Wait a minute.
that's more of it. Well, you put it several different places.
Yeah, I did. Those are all civil cases.
Yeah.
All right. How about August the 24th?
That one is a criminal you put on there.
Yeah, but that's a newer one. Is that available for you, Mr. Wagner?
Your Honor, I have stuff, but it can all be moved. This takes precedence.
Yeah, I have one or two. I have some civil matters, but those can be.
I've got minor pre-trials that can get shuffled, Your Honor.
All right. All right, and then assuming that this goes to trial, and this doctor's testimony is going to be necessary, has there been an agreement that that would be by Zoom?
Yes,
He doesn't have to
I
come
believe.
back here.
I think the party's still, I'm fine with that, sir.
Okay.
So am I, Your Honor.
All right. So that will mean that might want to notify him of that as well.
I spoke to him about that when I
All right.
talked to him to secure him.
Okay. All right. So we'll set it for August the 24th at 8 a.m. And Mr. Keltz, you understand we're continuing this because of the need to have this report and have you and your attorney and the state have it in advance, a couple weeks in advance, so they'll be prepared to deal with it. And that's going to require a continuance of your speedy trial time. You understand that?
Yes, sir.
Are you in agreement with that?
Yes, sir.
All right. So you waive your speedy trial time. Okay.
Yes.
All right. So then we'll set a final pretrial. Well, hopefully he has the report before August the 8th, because I hate to set it just then. But let's see. How about August? Now let me see what date that is. August the 10th would be, I think, a Monday.
We have trials that day.
Yeah, it'd be trials that day. So about August the 11th at 2 o'clock. That work for you, Mr. Wagner? It's a Tuesday afternoon.
I guess respectfully, Your Honor, I was just going to make them all work. I wasn't going to make it an option.
All right. I mean, as long as you're not going to be out of town or something like that.
No, there's no vacations. I've already used mine up this year.
All right. All right. Okay, so that'll be the order of the court. Now, do we have any other matters we need to discuss at this point?
Not from the defense counsel. Sorry, Annika.
That's okay.
All right. So the court will, on the oral motion of the defendant, grant the motion to continue. The final pretrial will be August 11 at 2 p.m., and the trial date will be August the 24th at 8 a.m., and defendant has waived time. And as far as discovery, has that all been completed other than the doctor's report?
I think I would still owe the state anything. I'm kind of waiting for that report, Your Honor, to see what it says. But I can do a supplemental.
Okay. Well, since you both jointly agreed to it and you're both going to get a copy of the report, I mean, that doesn't have to be added to discovery. But, I mean, if there's anything else that you think might need to be added that might be relevant, like names of witnesses or things of that nature, I'd like you to get that done before the final pretrial.
Yes, sir.
All right. Anything further from counsel then?
No, sir.
All right. Thank you. Ohio versus Shane Pitts. And you're Shane Pitts appearing there from the jail?
Sure.
All right. This is a hearing being conducted by Zoom, a pretrial. Mr. Pitts is appearing from the jail. His attorney is Danielle Witt. She's appearing from her office. And appearing on behalf of the state is Prosecuting Attorney Collins from her office. This was set for a final pretrial, and I do see that there's a plea form here in the file. Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Mr. Pitts?
Yes, sir.
All right. Since you're not seated in the courtroom next to your attorney, if at any time during this hearing you would like to speak with her about anything, you just tell me, and then I can put you and her into what's called a breakout room. It will be just the two of you on the screen. Nobody else will be able to see you or hear you, and the deputy will step out of the room while that consultation is taking place so that it's private, okay? And you need to speak up because you're,
Yes, sir.
your microphone's a lot further away than mine is, so I have a little trouble sometimes picking it up, and we need to make sure the recorder's getting it, so thank you for keeping your voice up. All right, Mr. Pitts is charged with 3 counts of aggravated trafficking of methamphetamine, 3 counts of aggravated possession. And we have a trial date set, I believe, July, it wasn't set in June, it was continued to July 20th. Now, I have this plea agreement form here, Mr. Pitts, which indicates that you are going to withdraw your not guilty plea and plead guilty to counts 1 and 3. I'm going to hold the first page of this document up to the camera. It has the name, case number, plea of guilty, and those 2 counts. You see that?
Yes, sir.
Do you recognize that document, Mr. Pitts?
Yes, sir.
On page 3, there is a sentence that reads, enter this plea voluntarily. Immediately below that is a line for signature defendant, and I'm looking at what appears to me to be Shane Pitts on that line. Is that your signature that I'm holding up to the camera? When did you sign this, Mr. Pitts?
Today.
All right. When you signed it, did you understand that it was an agreement to plead guilty, meaning there's not going to be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And before you signed it, did you go over it with your attorney and have her explain it to you and answer any questions that you had?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
And you've discussed what might happen in this case before you got the plea agreement?
Yes, sir.
All right. And did you sign this agreement voluntarily?
Yes, sir.
All right. And are you going forward with it now this afternoon voluntarily?
Yes, sir.
All right. So the agreement says you're going to plead guilty to counts 1 and 3, both aggravated trafficking of methamphetamine in violation of section 2925.03A1, both third-degree felonies, and indicates you understand that each of those carry a possible sentence of between 9 and 36 months imprisonment, a fine of $10,000, and a max mandatory fine of $5,000. And if those sentences were to be served consecutively, that means you have a total possible sentence of 9 months of minimum if they run together. And if they were to be served consecutively, it could be as much as 72 months. The total fine could be $20,000, and the total mandatory fine could be $10,000. You understand all that?
Sure.
All right. And in this case, these offenses are presumed to require a prison term, but it's not mandated. But the legislature says that generally there should be a prison term for this type of offense, but it's still up to the court. You understand that?
Sure.
Right now, Mr. Pitts, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, Mr. Pitts, if you plead guilty to these offenses and are sentenced to prison, once you complete that prison term, the law provides that the Adult Parole Authority has the option, if they choose to exercise it, to put you under post-release control for a period of up to 2 years under the terms that they set. So you'd be supervised by a parole officer under those terms. And if during that period of time they determine that you had failed to comply, then the Adult Parole Authority has the right to return you to prison to serve a sanction for those violations of up to 9 months for any single violation, but there's a cap or limit of half of whatever the prison term was for all violations. If you are convicted of a new felony, though, and sentenced to prison while on post-release control, supervision, then the judge in that case could also sentence you for committing that offense while on post-release control in this case to an additional period of 1 year or whatever time was left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, as I indicated, it's not mandatory that you be sentenced to prison for this offense, although it's presumed that that's the appropriate sentence. So under the law, the court does have the right to place someone convicted of this offense on community control, meaning probation, for a period of up to 5 years under terms set by the court. If during that period of time probation felt that you were not compliant, they would file a written notice of that with the court. There would be a hearing at which you'd be entitled to have an attorney, and if the outcome of that hearing was that you'd failed to comply, then at that time, community control could be revoked. You could be sentenced to between 9 and 72 months of incarceration and fined $20,000. And if you committed a new felony while on community control in this case and received a prison term for that offense, that sentence could be ordered to be served consecutively to the sentence in this case. Do you understand that?
Yes, sir.
All right, now the charge in count 1, Mr. Pitts, alleges that on or about March 25, 2025 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. Count 3 is the same offense, the same allegation, except it alleges that it occurred on June 9, 2025, but otherwise the same offense with the same penalties that I described earlier for both counts. Now, Mr. Pitts, do you understand what it is you're charged with in each of those counts, what the state said you did, when, where, and how they alleged that you did it? Now, have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at a trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs there at the jail?
Yes, sir.
And are any of those medications interfering with your ability to understand what you're reading or hearing or talk with your attorney or to answer questions for the court?
No, sir.
Okay. Now, has anyone threatened you to make you plead guilty here today, Mr. Pitts?
No, sir.
Now, on page 2 of the agreement, at the bottom, there are about a little over 4 lines printed in bold and underlined, which I will read into the record at this time. Defendant will enter a plea of guilty to count 1 and count 3. State will dismiss remaining counts. State and defense jointly recommend 18 months of incarceration on count 1, consecutive to 18 months of incarceration on count 3. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay buy money to the task force in the amount of $385. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, the matter of sentence is up to the judge, not the parties, Mr. Pitts. So even though there's a recommendation, the sentence should be 18 months on each count consecutive for a total of 3 years, 36 months. That's not binding on the court. If you plead guilty, the court can sentence you to any period of time between 9 and 36 months on each count consecutive as authorized by law. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
Now, you have certain constitutional rights you must understand before I can accept the plea from you. First of all, you have a right to have an attorney, and I appointed Ms. Witt to represent you since you didn't have the money to hire your own attorney. Now, her appointment wasn't made simply to get the case worked out, but to provide any defense that could be available to you under the law that you'd like her to provide. So if you decide that you don't want to do this, that you would rather defend against the charge, she'll continue to represent you, including trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are seated, the evidence is presented. They're then instructed on the law by the judge, and that jury of 12 decides by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt on either or both charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive that right, which means you give up the right to have a court or a jury trial, in which case you would then have what's called a court or bench trial, meaning it would be the judge who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the law, Mr. Pitts, you have the right to confront the witnesses against you in open court, to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
All right. Now, under the law, you have the right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in public in front of you, your attorney, and anyone else that's observing. And after the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Under the law and the Constitution of this country, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can. It's up to you. If you exercise that right, decide not to testify at your trial or during the proceedings at any time, the fact that you did that cannot be used against you in any way, at any time, by any person, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the law and the Constitution of this state and the country, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. A not guilty plea denied the allegation in the indictment, denied you committed any crime, and then exercised or invoked all the rights that I have just described for you today. Now, if you change your plea today from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime in each count. And that plea waives, gives up all the rights I've explained for you today, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you or cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove your guilt on either count. It also subjects you to being sentenced immediately by the court, which is what's likely to happen. And it waives, gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the two charges or the penalties?
No, sir.
Do you understand them?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand that the recommendation on sentencing is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
Do you understand them?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that here today?
No, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak to Ms. Wood about before we go any further?
No, sir.
And is it your decision, Mr. Pitts, to go forward voluntarily with this plea of guilty to these two charges pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
All right. And then as to the charge in count 1, which alleges that on or about March 25, 2025 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, or less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months in the increments provided by law, and a fine of $10,000, a mandatory fine of $5,000. How do you plead?
Guilty.
As to count 3, which alleges the same thing, except that it occurred on June 9, 2025, but also a third-degree felony with the same penalties as count 1, how do you plead?
Guilty.
All right. The court finds on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas of guilty to counts 1 and 3 are accepted in order to file. Defendants found guilty of each of those offenses as charged. Third-degree felonies, counts 2 and 4 through 6 are dismissed. Now, given the nature of the offenses, the agreement of the parties, and the defendant's criminal history based on the discovery compliance in the file, the court is going to go ahead and proceed with sentencing. Anything from the state?
Only what's contained within the plea agreement, Your Honor, including the repayment of the buy money to the task force. Thank you.
Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation that's in the plea agreement. I believe since he has been incarcerated in the jail, he has been making the most of his time and completing educational certificates. I believe he told me this morning he's completed 37 of them. So it seems that he does want to turn his life around, get on the right track, as well as he's also interested in treatment after his release as well.
All right, Mr. Pitts, is there anything you would like to say? Well, Mr. Pitts, you've had quite a history. Going back to, it looks like 1990. How old are you?
54, Your Honor.
Well, you've spent an awful lot of time. You know, as they say, the old song goes, I fought the law won. You've been losing for a long, long time, so you might want to think about changing your ways. Hopefully you will, because, this doesn't, it's hard on somebody to spend this much time in the system, and, it can certainly end up shortening your life. So I hope that you do make some changes once you complete your sentence. It is the order of the court, then, that you be and are hereby sentenced in each count to a term of 18 months. And those are to be served consecutively. The court finds that the recommended sentence is the recommended sentence of the parties. Also, that these were committed as part of one or more courses of conduct, and the harm caused is such that one. Could you bring me the list of all those, please? All the cases. I left it in there. Okay. One sentence will not accurately reflect the seriousness of the offenses and the harm caused, and the sentences being imposed is not disproportionate to the harm that was caused. The sentences are mid-range, and the defendant does have a lengthy record, and the defendant's previous criminal history demonstrates that a consecutive sentence is necessary to protect the public. All right. Now, the defendant, does my sheet from the sheriff's office indicate you were arrested on June the 27th? Is that right, Mr. Pitts?
No, I was arrested April the 8th.
I'm sorry?
I was arrested April the 8th.
That's correct.
What date?
April the 8th.
Yeah.
Oh, well. Okay, this form is confusing. He has the date. He has 6/20. Oh, okay. 6/27 is the 7/1. Oh, this was run on 6/26. Okay. All right. So April the 8th. Right. That was the date, April the 8th?
Yes, sir.
All right. That's what the report has. I was reading it wrong. All right. So that means that as of today, you have 85 days of jail time credit. So you'll be given credit against that sentence for that amount. Now, upon completion of this sentence, The Adult Parole Authority does have the right, if they choose to exercise it, to put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set by a parole officer, and if they determine that you have not complied, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge could also sentence you for committing that offense while on post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that has to be served consecutively in sentence in the new case. It's also ordered you pay restitution to the Highland County Task Force in the amount of $385 to be paid through the Highland County Victim Witness Restitution Escrow Account, and you'll pay any service fees required for that. You're also ordered to pay the court cost, and if you don't pay those, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or any other assets you may have. They could also then refer to collections, in which case you would have to pay an additional 30% above what you owe for the collection agency. And if none of those methods work, then the court could permit you to do community service once you're released from prison in this county and give you credit for each hour you worked in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded back to custody then. Thank you. All right, Anthony Simich, please. All right, case number 26 CR 45, State of Ohio versus Anthony S. Simich. Are you Anthony S. Simich appearing there from the jail?
Yes, sir.
All right, Mr. Simich, this is a pretrial. Mr. Simich is represented by Jacob Wagner, who's appearing from his office. Appearing on behalf of the state from the prosecutor's office is Prosecutor Collins. This is a final pretrial. Defendants charged in an 8-count indictment, along with 2 co-defendants in certain charges. Is set for trial. Let's see here. July the 6th. All right. Now, Mr. Simich, I have here a plea of guilty form, which indicates you're going to withdraw your not guilty plea to plead guilty. And Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir. We've talked about it.
And you're all right with that, Mr. Simich?
Yes, sir.
All right. Since you're not seated in the courtroom next to your attorney at any time, if you'd like to speak with him, you just tell me. I'll put the 2 of you in a breakout room. It'll be just you and him on the screen. None of the rest of us will be able to see you or hear you, and the deputy will step out of the room while you're consulting with him, okay?
Yes, sir.
All right. So, Mr. Simich, I have here a form that indicates that you're going to withdraw your not guilty plea and plead guilty to counts 1 and count 7. And this is a 5-page form. And I'm going to hold up to the camera the first page, and it has your name, case number, says plea of guilty to counts 1 and 7. And do you recognize that document there, Mr. Simich?
Yes, sir.
And on page 4, I believe, there is a sentence at the very bottom, the last sentence that reads, I enter this plea voluntarily. Below there, there's a line for signature of defendant, and I'm going to hold this up there. I'm thinking that that's your signature on defendant's line, Mr. Wagner. And his
We did. We got flipped around out there at the jail, Your Honor.
All right. So, is that your signature on the line above which is indicated defendant's attorney?
Yes, sir.
All right. And when you signed this agreement, did you understand that it was an agreement to plead guilty meaning there will not be a trial, and the next step in your case would be a sentencing hearing.
Yes, sir.
And before you, when did you sign this agreement?
Yesterday.
And before you signed it, did you go over it with Mr. Wagner and have him explain everything to you?
Yes, sir.
And you feel you had enough time to fully consider the matter before making the decision?
No, sir.
You do not?
No, sir.
All right. So why did you go ahead and sign it then if you didn't have enough time?
I made a hash decision. Last week when we were in front of you, we asked to vacate the trial and waive speedy, and you agreed to that.
May I address that, Your Honor?
Sure.
Maybe what Mr. Simmons is discussing. At sentencing, he was asking me to make a request to delay his sentencing. He's not wanting to delay this process. He's trying to take care of all of his personal items before he's shipped off. He's having some POAs brought to him. He's getting stuff put in storage. He's just afraid he'll get ran out to his parent institution before that's done. I think that's going to come here like the 10th or 12th, Your Honor. So he was hoping to delay being shipped out or have sentencing at a later date.
All right. Is that what you meant, Mr. Simmons?
Yes, sir. My brother's going until the 12th, and then on the 13th he'll be back, and we're doing all these paperwork and everything.
All right. So it's not the fact you were rushed into signing this agreement, but what you would like is more time before you're sentenced.
Sir.
Okay.
Yes, sir.
All right. Well, that's a different issue, and I'll listen to that, and I'm inclined to try to do something to accommodate that. But right now, let's just focus on the agreement itself. And that is, did you have enough time to think about it and talk about it with your attorney before you signed it?
Yes, sir.
All right. And did you sign it voluntarily based on the circumstances you find yourself in?
Yes, sir.
And are you going forward today with the plea voluntarily?
Yes, sir.
All right. Now, as I said, the agreement says you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1, a third-degree felony. In count 7, the same charge, the same section number, a second-degree felony, and that's because of the amounts alleged to be involved, I believe, in the 7th count. Now, it states that you understand that the penalty for these are as follows. As to count 1, it provides for a sentence of a minimum of 9 months, the maximum of 36 months of incarceration, and a fine of $10,000, a mandatory fine of $5,000. As to count 7, it provides for a minimum sentence to be set by the judge of between 2 and 8 years, a maximum fine of $15,000, a mandatory fine of $7,500. Now, count 2 is subject to what's called the Reagan-Tokes law, which is mentioned in your agreement here that I'm looking at. And what that means is that for persons that are convicted of first or second degree felonies, and count 7 is a second degree felony, that means that whatever sentence the judge imposes between the range permitted by law, which in this case is between 2 and 8 years, that the Department of Corrections Rehabilitation has the right to extend that time. So the way it works is that once you reach the time imposed by the judge, less any credit you had before you were delivered to prison, that is the presumptive date that you would be released. However, that is called a rebuttable presumption, meaning that it can be overcome. And there's a procedure that's provided that the Department of Corrections has to have a hearing in which they have to present evidence that overcomes the presumption you should be released on the date that you should be based upon the sentence of the court. And they have to make, in order to extend that time, the department has to make specified determinations regarding your conduct while you've been confined, your rehabilitation, any threat to society that you may pose, if you were in restrictive housing while you were in custody, and what your security classification was. And if the findings regarding those criteria are made that are such that it overcomes presumption, then the department can then extend your time for an additional period of time as they determine appropriate or reasonable. And they can do that on more than one occasion. However, there is a cap or limit of the amount of time they can extend it by, and that is 1/2 of the term that was set by the judge. And so if we use the worst case scenario of 8 years, they could extend it by 4, meaning that the possible term on that case would be 8 to 12 years. The 8 being what the judge said, the 12 being what the department could do. And so when you add that up with the sentence of 9 to 36 months in count one, if those were to run concurrently, that would be 2 years because the 9 would run with the 2. If it was the maximum of 8 years and the 36 months were added to the sentence, that means that it could be, in this case, 15 years maximum. 3 years plus the 12. Worst case scenario. Now, do you understand that? I'm sorry?
Yes, sir.
Okay. If you would, keep your voice up just a little bit because you're a little bit away from the mic and sometimes it doesn't come through too strongly. All right. Now, also, I believe that you are under post-release control at this time. Is that correct?
I just maxed out.
Oh, did you?
Yes,
All
sir.
right. Let me look here and see. Okay, we have a notice filed on April 9th. Let me take a moment here. I have a call I need to take. I'll put you on mute. Hi, Aaron. This is Rocky. I picked up. Hello? right, I apologize for that. It's a call I've been waiting for all day about a major event, so I had to take it. So we're back on record on State versus Simich. Now, Mr. Simich, I have a notice here that was filed on April the 8th that indicates that at that time, your time remaining under PRC was 503 days. So that would leave 22 days in April, 31 in May, 30 in June, and 1 today. So if we add that up, that is 83 days. You subtract 83 days from 503, and you get 420 days.
Guys, does this even apply since he committed these crimes before being placed on PRC?
Oh, no, it does not. It does not.
Yeah.
So that's what,
Okay, so that's because
that's
I
what
didn't
we
know
were
that.
thinking. That's why we didn't include that in this.
Okay, all right. Well, at least we need to get it on record, so I'm glad that you brought it up. All right, so then, so basically, then, it's my understanding that since these offenses were committed February 19th and 25 and March 3 of 25, and he was put on PRC when?
November of 25.
November. Okay. And you agree with that, Mr. Wagner? All right.
Yes.
So then the court finds that the PRC does not apply in this case. So you don't have to worry about that, Mr. Simich. Now, however, my understanding is that once you're sentenced, then that time will not run, and I think, I'm not sure, but I believe that's the way it works. And that
I just did my sanction time, which would have killed that anyways. That's what I was saying.
Okay. Well, I don't know.
Be quiet, Mr. Simich.
That'll be between you and the department. I just want you to know that whatever happens here, you may still have some time left on that. I don't know, but that has what we're doing here will have no effect on your PRC.
Yes, sir.
All right. Okay. So you okay now?
Yes, sir.
All right. I think I got you a little stirred up there, and sorry I had to take a break. I just prolonged your agony. So, but I did not realize that the offenses were alleged of being committed here were dated before that. So, because it, okay. So anyway, now, if you are sentenced with prison, well, and actually, going back, I didn't tell you that count 7 is mandatory. And so I don't have any choice but to put you on, to sentence you to prison. And so whatever sentence is imposed by the judge, that has to be served. And then the non-mandatory term comes after that. You understand that?
Yes, sir.
Okay. So once you complete your prison term, then it is mandatory under the law that you be placed on post-release control supervision as to count 7, sorry, the second-degree felony is where I got the 2 from. And that will be for a period of at least 18 months and a maximum of 3 years at the discretion of the parole board. And since you're on PRC, you know how that works. You're supervised by a parole officer under terms set by the APA. And if they determine that you've not complied, they could return you to prison to make you serve as a sanction up to 9 months for a single violation, but there's a maximum or cap of half of the prison term for all violations. But if you commit a new offense that was committed while you're on PRC, not before, then in that event, the judge in that case could sentence you for committing that offense while on PRC, in this case, to an additional period of 1 year, whatever time is left on the PRC set by the APA. Whichever is greater, and if that occurred, that would have to be served consecutively to whatever sentence the judge in that new case imposed. You understand that?
Yes, sir.
And again, you understand community control is not possible in this case because of the mandatory sentence.
Yes, sir.
All right. Now, you understand the nature of the charges and the possible sentences,
Yes, sir.
and you've discussed those with your attorney?
Yes, sir.
Have you also discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with him?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs there at the jail?
Yes, sir.
Do any of those interfere with your ability to understand what's going on when you talked with Mr. Wagner yesterday and read the agreement, or what we are doing here today?
No, sir.
All right. Now, on page 2, there are several lines printed in bold and underlined, and they read as follows. Defendant shall enter plea of guilty to count 1 and count 7. State will dismiss remaining counts. State and defense jointly recommend 12 months incarceration on count 1, consecutive to 3 years mandatory incarceration on count 7. Defendant agrees to cooperate fully with the task force and cooperate fully in the prosecution of all co-defendants. Defendant agrees to repay by money to the task force as follows: $280 joint and several with Kendra L. Holbert, $140 joint and several with Joey I. Vital, and $230 alone. You understand that?
Yes, sir.
Now, is that your agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement to what the sentence ought to be if you plead guilty, the court's not bound by that agreement. I could impose any sentence that's appropriate between in the court's view, between the 9 months and 72 months, or 9 months and 36 months on count 1, and the 2 to 8 year mandatory on count 7, and fine you as well. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir, not right now.
All right. Now, you have certain constitutional rights you must understand before it can accept a plea of guilty from you. First of all, you have a right to have counsel, and I appointed Mr. Wagner to represent you. That appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you'd like him to provide. So, if you decide that you do not want to do this, that you would rather defend against the charge, he'll continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
Now, under the law, you have a right to a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence is presented, they're then instructed on the law by the judge, and that group of 12 will decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning it would be the judge who would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of this state, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. That means that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions, and that's called cross-examination, the purpose of which is to try to bring out evidence that could help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're uncertain going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, but no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution and the laws of the state, you have a presumption of innocence, which means that you're presumed innocent of the charge until, in each case, until proven guilty by the state of Ohio on every essential element of each offense. So what further means is that you're not required to try to prove you're not guilty simply because you've been accused. In fact, you don't have any burden of proof at all, and you're not even required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty, that's the opposite of the not guilty plea. Guilty plea admits the allegation in each of those two counts, counts 1 and 7, admits that they're crimes, that you committed those crimes, and those pleas waive or give up all the rights that I've explained for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives gives up your right to a jury or court trial, waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. Waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf. Yet waives gives up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. And waives gives up your presumption of innocence because if you say you're guilty as to these two charges, then the state's not required to prove your guilt. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charges or the penalties as to counts 1 and 7?
No, sir.
You understand?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
And you understand?
Yes, sir.
Now, is there anything you'd like to speak to Mr. Wagner about before we go any further?
No.
Is it your decision to go forward and plead guilty to counts 1 and 7 pursuant to the terms of this plea agreement that we've just gone over?
Yes, sir.
And are you doing that voluntarily?
Yes, sir.
All right, then as to count 1, which alleges that on or about February 19, 2025 in Highland County, Ohio, that you and Joey I. Vital did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, a third-degree felony carrying possible term of between 9 and 36 months of incarceration, fine of $10,000, a mandatory fine of $5,000. How do you plead?
Guilty.
As to count 7, which alleges that on or about March 3, 2025 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. The same charge, but a second-degree felony carrying a mandatory minimum set by the judge of between 2 and 8 years, and a possible extension of that by up to 1/2 by the DRC under the conditions I mentioned earlier. How do you plead? Well, it also carries a fine of $15,000 and a mandatory fine of $7,500. How do you plead?
Guilty.
All right, thank you. All right, the court finds that on this day at open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Pleas are accepted, orders filed. Defendant is found guilty of counts 1 and 7 as charged. The remaining counts are dismissed as to this defendant. Since this is a mandatory sentence, there is no need to order a pre-sentence report in the court's view. There is a request for a deferred sentence, and What date, Mr. White, did you say he was looking to be able to remain here?
Your Honor, I believe Anthony indicated to me his brother was getting back from wherever he was on the 12th and would be out to have the documents for him to sign and execute on the 13th.
Okay.
So if the court, and we greatly appreciate it, would accommodate maybe the 13th or the 14th, sir, in that time period.
How about the 15th at 10 a.m.?
Yeah, I'm upstairs in domestic relations court. I can come over, Your Honor.
All right. So the sentencing will be July the 15th at 10 a.m. And defendant will remain in custody until then. All right. Anything further from counsel?
No, sir. Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
You're welcome. I'm going to go ahead and do Mr. Rickman there since he's at the facility and his attorney is just logged in. Never mind. This is State of Ohio versus Bryson Rickman, 26 CR 30, and you are Bryson Rickman, appearing on the screen. Mark Bryson Rickman.
Yes, sir.
Okay. All right. So Mr. Rickman is charged with failure to comply with the order of signal of a police officer, a third-degree felony, and this is I see there that there is a provision for a sentence and then no position on judicial release on this plea agreement. I'm thinking, counsel, what we ought to do is just go ahead and set this for in-person hearing, and rather than set a separate sentencing. So I'll say I would propose we do that sometime next week. Mr. Armentrout, is that available?
That's fine, Your Honor. Did you get it?
Okay, you're
get it signed and everything today.
Yeah, it is signed, but given the recommendation, the nature of the offense, rather than go through it here today, I think we just need to set it for a hearing and get us a date. So
That's fine.
how about Thursday at 10 a.m. in person, July the 9th?
I've got several hearings in municipal court in the morning, Your Honor.
All right. What about
Do the afternoon?
Yeah. I could do the. All right. How about Friday at 11:30, the 10th?
Judge, I'm going to tell you that will work. I've got a guardianship hearing at 10, but I don't think that'll take more than an hour. So.
All right. Well, I have an 11 o'clock sentencing, so we'd do this after that. All right.
11:30.
All right.
Okay.
So, Mr. Rickman, then your hearing will be set for next Friday, the 10th of July at 11:30 a.m. here in the courthouse. All right.
Judge, are they going to transport him up here?
No. I mean, well, that's up to them, but he's going to have to get here one way or the other. He's there voluntarily, isn't he?
He is.
All right. So that was, you'll have to make your own way up here unless they want to bring you up, Mr. Rickman. That's up to them.
All right.
All right.
Judge,
Yes.
typically any time is fine with my office. However, that time is actually not.
Oh. Okay.
Earlier in the morning on July the 10th is fine.
All right. Well, Mr. Armstrong has some hearings out in municipal court that day.
No, on the 10th, but I've got hearings in the morning on the 10th also. The last one was at 10, but I've got a 9 and a 9:30.
Well, how about 1 o'clock on the 10th?
No, Judge, later is not good.
Well, you didn't say the date. You said the day, or that date and time. So the whole day's bad?
No, later than 11:30 is bad. Like 11:30 and down is bad. I said it could be earlier in that day, but not
Well,
later.
It can't be because Mr. Armentrout's scheduled. So, what about, you say you have hearings in the morning on the Thursday?
I do, yes,
All right,
Judge.
well, let's do 1:15 on the 9th. Are you available then?
I can do that.
All right, 1:15 on July the 9th. I have a couple of webinars, but I have one's 12 to 1 and one's 2 to 3:30, so I have an hour in between. So we'll do 12:15 on July the 9th. I'm sorry, 1:15 on July the 9th. All right, so you'll need to be here for that, Mr. Rickman, and if the facility won't bring you, you'll need to make your own arrangements.
Yes, sir.
And otherwise, you'll be subject to being charged with failure to appear, which is another felony. All right, thank you.
Thank you.
All right, just do an entry on that. All right. Case number 26 CR 55, State of Ohio versus David Bennett. This is a pretrial. You're David Bennett appearing there from the jail?
Yes.
All right. This is a Zoom hearing, and Mr. Bennett's attorney is Jacob Wagner. He's appearing from his office, appearing on behalf of the state, representing is the prosecuting attorney, Annika Collins, from her office. The defendant is charged with aggravated trafficking and methamphetamine and theft by deception. The trial is set for July the 23rd. This is the final pretrial. I have been presented with a plea of guilty form. Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
We are, sir. We discussed it this morning.
All right. Is that all right with you, Mr. Bennett?
And this is my final pretrial. I thought this was my first pretrial.
Is it? We had a...
no, sir.
No, it was noticed as your final pretrial, is what the assignment notice said.
I was obvious that, no.
We had a previous pretrial, I think, with your first attorney.
Yeah, he pulled out, and I haven't been back and seen you since.
Well, yeah, I mean, that's because he withdrew, and then I appointed Mr. Wagner, and you've talked with Mr. Wagner, right?
Just one time this morning.
All right. All right, so, are you...
Yes.
I'm sorry, what?
Yes. Yeah. Yeah, I'm ready to plead.
Okay, all right. So, this is a form I'm looking at is a plea of guilty form. It's 3 pages long. I'm going to hold up the first page, which has your name and case number, and says you're going to plead guilty to count 1. You recognize that document?
Yes, sir.
Yeah, it's let's say, and the count 2, Miss Collins, the alleged victim would be the task force? Is that who we're talking about?
It is the task force, Judge.
All right, so they're not exercising any rights as alleged victims?
No, they're not.
All right. Now, on page 3, Mr. Bennett, there is a sentence that reads, I enter this plea voluntarily, and below that there appears to be a signature of David Bennett. I'll hold that up to the camera. Is that your signature?
Sure.
And when did you sign this, Mr. Bennett?
This morning.
And when you signed it, did you understand that it was an agreement to plead guilty, which means you won't have a trial, and the next step in your case would be a sentencing hearing?
Yes.
And before you signed this, did you talk with Mr. Wagner and have him explain everything to you and ask him any questions about it that you had?
Yes. Yeah.
And you indicated you'd only spoken with him once. Are you satisfied with his advice and competence at this time?
Yeah. But I was thinking maybe if I could have a couple of days to talk to my family about it. I'm in the hole currently, and I haven't had a chance to talk to my family at all.
Why are you in the hole?
I had a disagreement with one of the staff members.
I see.
And I haven't had a chance to talk to my family about this at all.
All right.
And,
well, I have no problem with continuing this. When are you going to be able to see your family?
Get out of the hole.
When is that?
3rd. I get out of the hole on the 3rd.
On the 3rd?
Yeah.
All right. Well, that would be Friday.
Right. Yeah.
All right. So this is set for trial. I think I said, what was it, July the 23rd? All right.
Yes.
let's see, we don't have any trials Monday, do we, the 6th? Well, you going to have visitation day over the weekend?
Well, I know.
Pardon me?
No, I don't get visits.
Judge, they don't do in-person visits anymore.
Oh.
You get a video. He can once a week you get a free video visit and a free phone call, and he gets those on Sunday.
That would be the 5th.
Yeah.
Okay. All right.
Mr. Bailey, am I correct about that?
Yes, ma'am, you're on.
All right. All right. Well, then on the 5th, you can talk to your family, and if they're available, and then we'll go ahead and have the hearing then on July the 6th at 1 o'clock.
Okay.
All right. Then we'll see you back here then. Thank you.
Okay, thank you.
Case number 26 CR 56, State of Ohio versus Dylan Tate Campbell. Are you Dylan Tate Campbell?
Is that still going?
What is it?
Monday, 2:50 meeting? I know you had something.
Yeah, it is.
Will you be done by 1?
I will be.
Oh.
And if I'm not, I'll have to wait. All right. Case number 26 CR 56, State of Ohio versus Dylan Tate Campbell. You're Dylan Tate Campbell appearing there from the jail. All right. And keep your voice up if you would. Mr. Campbell, this is a hearing being conducted by Zoom. His attorney is Jacob Wagner, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins on behalf of the state. The defendant is charged in an 8-count indictment with various drug offenses. And this is a final pretrial. And I think we have a trial date of July 20. Now, I have a plea of guilty form here, Mr. Campbell, which indicates that you are going to withdraw your not guilty plea and plead guilty to count 2. And I'm going to hold this form. It's a 3, maybe, in this case, it's 5 pages, I believe. 5-page document. I'm going to hold up the first page. It says your name and case number. Says plea of guilty to count 2. Yeah, no, sorry, count 7. And you recognize that document?
Yes, sir.
On page 4, there is the last sentence on that page reads, "I enter this plea voluntarily." Immediately below there's a signature, a line for signature of defendant. Above that, there's a signature, and I'll hold that up to the camera. Is that your signature there under that line?
Yes, sir.
When did you sign this agreement, Mr. Campbell?
A few hours ago.
And when you signed it, did you understand it was an agreement to plead guilty, meaning there won't be a trial, and the next step in your case will be a sentencing?
Yes, sir.
And before you signed this, did you discuss it with your attorney and ask him any questions about it that you had?
Yes.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
And do you feel that you were rushed or pressured in any way into doing this?
No, sir.
And are you going forward today with this plea voluntarily?
Yes, sir.
All right. Now, the agreement says on page 1, you're going to plead guilty to count 7. Aggravated trafficking of methamphetamine in violation of section 2925.03A1 of the Ohio Revised Code, a second-degree felony. Now, it further states that you understand that the term of this, that in this case, this is a mandatory prison term offense, and that means that the court would set a prison term of between 2 and 8 years as a mandatory minimum. There could also be a fine of $15,000 and a mandatory fine of $7,500. You understand that?
Yes.
Now, this is a second-degree felony, and so the term that I explained that the court sets, which is required by law to be somewhere between 2 and 8 years, but that is the mandatory minimum sentence. And under the Reagan-Tokes law, which is referenced here in your agreement, starting on page 1, That law provides that the DRC, Department of Rehabilitation Corrections, does have the right and the power to extend that sentence by up to 1/2. Now, the way that works is this. If you are guilty and you're sentenced, whatever sentence you get, let's say it's 4 years. When 4 years have passed and you get credit for all the time you've been awaiting trial on this charge, that you're being held on this charge, whenever you reach that date, there's a presumption that's the day you're going to get out. Now, under the law, the Department of Rehabilitation Corrections can extend that if they overcome that presumption. So in order to do that, there has to be a hearing that's held pursuant to statute by the department, and then they have to make certain determinations that would overcome that presumption. And the determinations are made regarding several things that include your conduct while you were confined, your rehabilitation during that period, any threat to society that you may pose, if you were under any kind of restrictive housing, and what your security classification was during your incarceration. And if they make the findings that regarding those criteria that overcome the presumption, then the department can extend your period of incarceration by time that it determines to be reasonable, additional time. And they can do that on more than one occasion. The amount will be up to them. Now, the limit on their discretion is this. It can't be more than 1/2 of whatever sentence was imposed. So if it was a 4-year sentence, the maximum could be 2 additional years. If it was a 2-year sentence, the minimum by the court, then it could be 3 years. If the court gave you 8 years as a mandatory sentence, they could extend it by 4 years. So that means that you would be facing, in this case, a total possible incarceration of between 2 years and 12 years. Do you understand that?
Yes, sir.
And are you facing any charges in any other county? I believe you are, aren't you?
Yeah, as of right now, yeah, Fayette County.
And is it for a felony?
Yeah.
If you are convicted of a felony, in this case, and sentenced to prison, which is mandatory, and if you're convicted in Fayette County and sentenced to prison, then those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
Now, other than the charge you're facing in Fayette County and this charge, are you under community control, probation, parole, or post-release control for a felony?
Just probation in Greene County.
In Greene County for a felony?
Yes, sir.
Okay. And have they filed anything on you yet on that, or are they waiting until these cases are done?
Probably gonna wait till these cases are done.
All right. Well, in the event that you are convicted of a probation violation in that case, and again, conviction of a crime in this case was most likely be a violation of your community control in that case. That's a standard condition that you're not committing any other crimes. If the judge up there revokes your community control and sentences you to prison, that can be ordered to be served consecutively to the sentence in this case. Do you understand that?
Yes, sir.
All right. Now, under the law, once you complete the prison term and are released from custody, it is mandatory as to this charge that you be put under post-release control supervision by the Adult Parole Authority for a period of at least 18 months up to a maximum of 3 years. And that means that you'll be supervised under the terms set by the APA by a parole officer. And if during that period of time that you're being supervised, they determine that you have not complied with those conditions, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of whatever the prison term was for all violations. But if you commit a new felony and are sentenced to prison while on post-release control, in this case, then the judge in that case could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
And again, in this case, community control or probation is not possible because it's a mandatory prison term. You understand that?
Yes, sir.
All right. Now, the charge in count 7, alleges that on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount in violation of Section 2925.03A1 of the Ohio Revised Code, a second-degree felony carrying a mandatory prison term of at least 2 up to 8 years as set by the judge, with the possibility that it could be extended by DRC under the Reagan-Tokes law by 1/2, meaning possible maximum of 12 years, a mandatory fine of $15,000 and a maximum fine of $15,000 and a mandatory fine of $7,500 would be the penalty. Now, you understand what you're charged with and what the penalties for that are?
Yes, sir.
And you understand what it is the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Now, did you discuss the charge, the evidence in the case, possible legal issues in the case, and possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, beginning at the bottom of page 2 and continuing on to page 4, there are several lines printed in bold and underlined. And then I see there's also been some ink written in on top at the end of that, and I'll read that along with the underlined bold part. So it reads, defendant shall enter a plea of guilty to count 7. State will dismiss remaining counts. State and defense jointly recommend 3 years of mandatory incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force in the amount of $464. State agrees not to pursue an indictment for having weapons under disability from the incident on May 12, 2026. And defendant agrees to forfeit the weapon to Greenfield Police Department. And that's reference to that May 12 incident, Mrs. Collins?
That's correct, Your Honor.
Right. So, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law of the matter, sentence is up to the judge, not the parties. And so if you plead guilty, the court doesn't have to follow that recommendation. I could impose any mandatory sentence between 2 and 8 years and fine you $15,000 if I thought that was the appropriate sentence. Do you understand that?
Yes, sir.
Right now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept a plea of guilty from you. You have a right to have an attorney, and if you don't have the money to hire one, the court appoints one for you, and I did appoint Mr. Wagner to represent you since you did not have the money to hire one. Now, that appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you wish him to provide. So if you decide you don't want to do this, that you would rather defend the charges and go to trial, he'll continue to represent you, including trial, if that's what you want. You understand that?
Yes, sir.
Now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After the 12 are selected, the evidence is presented. The court then instructs them on the law, and then that jury of 12 will decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case, you would then have what's called a court or bench trial, meaning the judge would be the one that would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
All right. Now, you have the right under the Constitution to use the power of the court to compel or force witnesses to be in court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here. which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the law, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge to proven guilty by the state of Ohio on every essential element of the offense. So that means that the burden of proof is not on you to try to show you're not guilty simply because you've been charged. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will always be on the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. Now, if you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in count 7 in the indictment, admits that it's a crime and that you committed that crime. And that plea will waive or give up all the rights that I've explained to you today, except the right to have an attorney, because you always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury or court trial. Waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. And waives gives up your privilege against self-incrimination because you're the one saying you're guilty, and that's what's used to find you guilty. The waives gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up your right to file an appeal on any alleged violations of your rights you feel could have occurred up until this point in the case. Now, if I sentence you the the maximum sentence, or under other certain limited circumstances, you could file an appeal. The appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Campbell?
Yes.
Now, do you have any questions about the charge or the possible penalty in this case?
No, sir.
You understand it?
Yeah.
Any questions about the plea agreement?
No, sir.
You understand it?
Good.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes.
Is there anything you need to speak with your attorney about before we go any further in this matter?
No.
You know, I don't think I put this on record, or if I did, I don't remember, but Mr. Wagner, you and your client are both okay with it going forward today by Zoom, since we're not...
We are, sir. We spoke about it this morning.
All right. And you're all right with that, Mr. Campbell, obviously?
Yes, sir.
Okay, thank you. All right. Then is there anything you need to speak with Mr. Wagner about at all before we go any further?
No.
Then is it your decision to go forward and plead guilty to count 7 pursuant to the terms of the plea agreement that we've just discussed?
Yes, sir.
And you do that voluntarily?
Yes.
Right, then as to the charge in count 7 that alleges that on or about August 14, 2025 in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding 5 times bulk but less than 50 times bulk, in violation of Section 2925.03A1 of the Ohio Revised Code. The charge of aggravated trafficking of methamphetamine, a second-degree felony carrying a mandatory minimum time of between 2 and 8 years is set by the judge with the power of the Department of Rehabilitation and Corrections to increase that by up to 1/2 pursuant to the Reagan-Tokes law that we talked about, a fine of $15,000 and a mandatory fine of $7,500. How do you plead?
Guilty.
All right, the court finds on this date, open court, defendant is advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accepted order filed. Defendant is found guilty of count 7. Counts 1 to 6 and 8 are dismissed. Given this is a mandatory prison term, also the fact that the defendant's facing charges in another county and on probation in a third county, the court's going to go ahead and proceed with sentencing. Anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor, including the forfeiture of the gun. The case has actually been bound over. We'll dismiss it as soon as this hearing is over. The form's already been filled out and signed.
Okay. All right, Mr. Wagner, anything you'd like to say?
Your Honor, we would ask the court to follow the recommendation of the parties. I'm not trying to be cute or funny when I say this, but, Dylan's never going to win Citizen of the Year. Obviously, he's got things pending in the various courts. But with that being said, Your Honor, he's been nothing but an utmost and respectable client to deal with. He's never looked at me and said, let's file a continuance just to waste their time, or let's have a trial to waste their money. He's taking responsibility from the jump in this case. The only reason this wasn't done quicker, Your Honor, is because he was up in Fayette County. It had to get brought back. He probably would have asked me to move this up on the docket. I would simply ask the court to go along with the recommendation. Again, may not mean a lot to the court, but it does to me. It was very easy to deal with him, Your Honor. And that's not because he took a plea. He was just respectful at all time.
All right, Mr. Campbell, anything that you would like to say?
I apologize to the state court, and, Greg's got a hold of me. Hopefully, what rehabilitation there is in prison, it'll help me out. We'll see.
Okay. Well, I'm looking at your record, and, the last 10 years, 11 years, you've just been in and out of trouble, and you've had supposed to do the Monday program in Fayette County back in 16. Looks like you had a violation, got 3 months there. And you had TIL going in Greene County, which is treatment, in 2024. That's the one you're facing, you mentioned. So, you need to make a decision what you're going to do. I know that it's tough, but if you don't get serious about getting and staying sober, you're looking at a long time coming in and out. I just dealt with a guy that's been doing it now. He's 54 years old. He's been doing it since he's about 19. Just dealt with him earlier, surprising he's made it that far. And people like you continue to do this, sooner or later it's going to catch up with you and end your life prematurely. But the court is going to follow the recommendation. So it is the order of the court that you be and are hereby sentenced to a mandatory term of 3 years at the Correctional Reception Center at Orion, Ohio. That is a mandatory term that has to be served. And then once you have served that term, less than a good time credit. And right now we have you spent 8 days in this on this case in jail, and then you got out on bond and you've been in custody in Fayette County. Is that correct?
Yes, sir.
All right. So once you have served the mandatory 3 years, including any jail time credit that you get, which is right now 8 days, then it's presumed that you'll be released on that day. However, the Department of Rehabilitation and Corrections does have the right to overcome that presumption by conducting a hearing under statute in which they have to make certain findings on several criteria, which include your behavior while you were, your conduct while you were confined, the extent of your rehabilitation, whether you posed any threat to society, whether you were placed in any restricted housing while incarcerated, or what your security classification was while you were incarcerated. And if their findings regarding those criteria overcome the presumption, then the department has the right to extend your sentence by an additional period that it deems reasonable. And they can do that on more than one occasion if they follow the same process. However, they cannot extend your term for, no matter how many times they do, by more than half of your prison term. So that means that they could extend it by up to 1/2, which would be, in your case, 18 months. So that means that your maximum sentence, in this case, your minimum is 3 years mandatory, and it could be up to 4.5 if they make those findings and decide to extend it. And then once you serve that extended term, then you'll be released on this charge. Now, once you complete the prison term and are released, the Adult Parole Authority must put you under post-release control supervision for a period of at least 18 months up to a maximum of 3 years under the terms they set. You'll be supervised by a parole officer, and if the APA makes the determination that you have not complied with those conditions, then they have the right to return you to prison, even though you serve the entire term, in this case, for an additional period of up to in this case, 9 months for any one violation, but there is a cap or limit of half of the prison term for all violations, which would be 18 months. However, if you commit a new felony while on post-release control and are sentenced to prison, then the judge in that case could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, it has to be served consecutively the sentence in the new case. Now, has there been any change in your financial circumstances since you were appointed counsel in this case?
No, sir.
All right, then the court finds you're not able to pay the mandatory fine and are unlikely to have the ability to pay it in the future, so it is waived. The firearm that's referenced in the plea agreement is ordered to be forfeited to the Greenfield Police Department. It's also ordered that you pay the court cost, and if you fail to pay those court costs or make payment arrangements to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then they can refer it for collections, who could charge an additional 30% above what you owe. And if none of those means collect it, then the court could permit you to do community service once you get out of prison. You can't do it while you're in prison because this community service has to be done in this county, and you would be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right. Restitution is also ordered, and that is $480, I think. $464 to the Highland County Task Force, and that's to be made through the Highland County Victim Witness Office restitution escrow account. You'll pay any service fees that are charged for that. All right, is there anything further from counsel?
What was his jail time credit again?
8 days.
Only 8?
Let me look here. Oh, actually, it's a little bit more than that. It was printed out on the 26th originally. So it looks like it would be, you were arrested on the 12th of May and released on the 22nd. Is that correct?
Yes, sir.
All right, so it says you were 8 days and 19 hours, so that's 9 days. And then you've been in jail since that time, right, in Fayette County?
I bonded out, and then I got arrested.
Yeah, you bonded out on May the 22nd, didn't you?
I can't remember, Your Honor.
Well, that's what they have here. Let me look. Yeah, the bond was posted on May the 22nd. And then since that time, you've been in custody of Fayette County when we brought you back, right?
Yes, sir.
All right. So 9 days is the amount. So 9 days of jail time credit.
Yes, sir.
All right. Anything further?
No, no.
All right. So you're remanded back to custody, and whenever they're done with you in Fayette County, I assume you'll be transported to prison. All right. Thank you. All right. Amy Rickman. All right, waiting on Miss Witt. All right. It's case number 26 CR 54, State of Ohio versus Amy Rickman, and you're Amy Rickman appearing there on the screen from Probation Department.
Yes, sir.
All right. This is a pretrial being conducted by Zoom. Rickman is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a final pretrial. Her trial date is July 23rd. Now, Ms. Rickman, first of all, Ms. Rickman's attorney is Danielle Witt, appearing from her office, and appearing on behalf of the state from the prosecutor's office, Prosecutor Collins. Now, I've been presented with a plea of guilty form here, Ms. Rickman, which indicates you're going to plead guilty to this charge. And first of all, Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Rickman?
Yes.
All right, since you're not seated next to your attorney in the courtroom, if at any time you would like to speak with her, just let me know. Put the two of you in a breakout room. Nobody else will be able to see you or hear you. It'll be just the two of you on the screen. You understand? Okay?
Okay.
All right. So, I have this plea of guilty form, which is a 3-page form that says you're going to plead guilty to the charge. It has your case. First page has your case number, name, and the plea of guilty. Count 1. I'm going to hold that up to the camera and ask if you recognize that agreement.
Yes, Your Honor.
And on page 3, the last sentence reads, I enter this plea voluntarily. And then there's a line for signature defendant. And is that your signature on that line, Amy Rickman?
Yes, sir.
When did you sign this agreement, Ms. Rickman?
Directly after court last week.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And before you signed it, did you discuss it with your attorney and have her answer any questions, explain it to you?
Yes.
Feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And since it's been a few days since you signed it, have you had any change of heart? Is this still what you want to do?
Yes, sir.
Which is it?
No, sir, I haven't had any hurt. It's still what I want to do.
All right, so you want to go for it?
Yes.
And you're doing that voluntarily?
Yes.
All right. Now, the agreement says that you're going to plead guilty to the charge of aggravated possession of methamphetamine under Section 2925.11 of the Ohio Revised Code of fifth-degree felony. As further states, if you understand that the maximum term for that is between 6 and 12 months of incarceration and a fine of $2,500. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, just Highland County. I don't kind of have anything in.
All right. Are you on community control, probation, parole, or post-release control for a felony?
Yeah.
In what court?
This one.
All right. What is it for?
Trafficking. I went to STAR last year and then to TCC.
Okay.
And I'm on community control right now.
All right. Well, in the event that you're found guilty of this offense by the terms of that probation order, it would be a violation of that order. So that means that technically it's possible that you could have that community control or probation revoked and be sentenced to a term of incarceration in addition to this, if you were sentenced in this case. You understand that?
Yes.
Okay. And that if those sentences are ordered to be served in custody, they could be consecutive to one another. You understand that?
Yes, sir.
All right. Now, under the law in this case, if you should ever serve a prison term, if you're convicted, on completion of that term, the adult parole authority does have the right, if they choose to exercise it, to put you under post-release control supervision under the terms they set for a period of up to 2 years, meaning you'd be supervised under the terms they set by a parole officer, and if during that period of time they determine that you had not complied, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if your violation is a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. Do you understand that?
Yes.
Now, under the law, I don't have to sentence you to prison for this offense. I can impose community control or probation, which you're familiar with, but I'm still required to explain to you. And that is that you could be supervised for a period of up to 5 years by the probation department under terms set by the court. If during that period of time they determined that, in their opinion, you were not compliant, they would file a written notice that with the court, give you a copy. There would be a hearing at which you would have the right to be represented by an attorney. If the outcome of that hearing was that you had committed a violation, then at that time the court could revoke your community control and sentence you to between 6 and 12 months incarceration and fine you $2,500. And if the same thing happened in the other case, that could be those could be served consecutively to one another. Do you understand that?
Yes, sir.
Additionally, if you commit a new felony offense on community control in this case and are sentenced to prison, that sentence could also be ordered to be served consecutive to sentences in these other 2 cases in this court. Do you understand that?
Yes, sir.
All right. Now, the charge in the indictment alleges that on or about August 11, 2025 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, which is the charge of aggravated possession of methamphetamine fifth-degree felony with the penalties I just described. Now, Ms. Rickman, do you understand what it is you're charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
Nope.
Now, on page 2, there are 2 lines that are printed in bold and underlined that read as follows. Defendant will enter plea of guilty to the indictment. State defense to recommend community controlled substance abuse treatment. That's your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. So even though there's a recommendation that you get community control, I'm not obliged to follow that. I could decide after I've heard all the information that you should be sentenced to prison or in custody in this case and the other case, and that those could be served consecutively. It could also fine you in each case. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
Do I?
Yeah, like something like a pharmacy tech, a vet tech, nursing assistant, something like that. Okay. All right. Now, you have certain constitutional rights you must understand before I can accept a guilty plea from you. First of all, you have a right to have an attorney, and I appointed Ms. Witt to represent you. Her appointment wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you'd like her to provide. So if you decide you don't want to do this, that you want to defend against the charge, she'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the law, you have the right to a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial. And after 12 of those folks are selected, the evidence is presented. The judge then instructs that jury on the law. Then that jury of 12 people will decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. If you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the law, you have a right to confront witnesses against you, to cross-examine them in open court through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the law, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, court issues a court order called a subpoena that forces those people to come to court to be able to testify if you want them to, even though they don't want to be there, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the constitutional laws in this state, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way, at any time, by anyone in the case. And in fact, no one can even talk about it with one exception. Should there be a jury trial and you elect not to testify, the jury is instructed, because that is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the constitutional law, you are presumed innocent until proven guilty by the state of Ohio of every essential element of this offense. What that means is the burden of proof isn't on you. Try to prove you're not guilty. In fact, at trial, you're not even required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime, and that plea Wage gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty. Wage gives up your right to a jury or court trial. Wage gives up your right to confront witnesses against you and to cross-examine them through your attorney. Wage gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. The wage gives up your privilege against self-incrimination because you're saying you're guilty. That's what's used to find you guilty. Wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, a wage gives up your right to file an appeal you think you could have had up until this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
Do you understand it?
Yes.
Have any questions about the plea agreement?
No, sir.
Do you understand it?
Yes, sir.
Again, you understand the recommendation on sentencing is not binding on the judge.
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
Do you understand those?
Yeah.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yeah. Guilty. Is that what those yes?
Do you have any questions?
Oh, no. No
Do you
questions.
understand then what would happen if you enter this plea today?
Yes.
Okay. Now, is there anything you'd like to speak with Ms. Wood about before we go any further?
No, sir.
Is it your decision then to go forward voluntarily and plead guilty to the charge pursuant to the terms of this plea agreement?
Yes, Your Honor.
All right. Then as to the charge, which alleges that on or about August 11, 2025 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11, our revised code, fifth-degree felony, carrying a possible term of incarceration of 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
All right. The court finds on this date, open court, defendants advised of all their constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to cruel weapon. Please accept that were filed defense found guilty of the charge in the indictment, the fifth-degree felony. The court orders a pre-sentence report be prepared by the probation department, and bond will be continued. We'll have sentencing in person here at the courthouse on August the 5th at 9 a.m. All right. Is there anything further from counsel?
No, Your Honor.
All right. You'll get an assignment notice there from the probation office, and then talk with them about an appointment for your PSI.
Thank you.
All right. Thank you. I think that's everything. All right.